Hello and welcome everyone to Law Books Simplified. So I am Advocate S.R. Paul from Calcutta High Court, and here we are doing the simplification of the book CPC by C.K.Takwani. And here in this book we are going through every line of every paragraph of every page of this book, and I'm trying to simplify them as much as possible. So on our last video we have done till the decree, and today we are going to start the preliminary decree, and we'll be doing three types of decree. And without any further delay, let's start. Preliminary decree, where an adjudication decides the rights of the parties with regard to all or any of the matters in controversy in the suit, but does not completely dispose of the suit. It is a preliminary decree. A preliminary decree is passed in those cases in which the court has first to adjudicate upon the rights of the parties and has then to stay its hands for the time being until it is in a position to pass a final decree in the suit. In other words, a preliminary decree is only a stage in working out the rights of the parties which are to be finally adjudicated by a final decree. Till then, the suit continues. So here it says that in preliminary decree we can see that that decides the rights of the parties, but that does not completely dispose of the suit. So in this case we can see that it adjudicates the rights of the parties, but it is not in the position to finally dispose of the suit. So until it finally disposes of the suit, it becomes a preliminary decree upon which the further inquiries of the courts will take place and a final decree will be given by the court. So here is some examples of preliminary decree. That is 1. Suits for possession and mensne profits, Order 20, Rule 12. Administration suits, Order 20, Rule 13. Suits for preemption, Order 20, Rule 14. Suits for dissolution of partnership, Order 20, Rule 15. Suits for accounts between principal and agent, Order 20, Rule 16. Suits for partition and separate possession, Order 20, Rule 18. Suits for foreclosure of a mortgage, Order 34, Rule 2 to 3. Suits for sale of mortgaged property, Order 34, Rule 4 to 5. Suits for redemption of a mortgage, Order 34, Rule 7 to 8. The above list is however not exhaustive, and a court may pass a preliminary decree in cases not expressly provided in the code. So here we have 9 examples of preliminary decrees, but this list is not exhaustive. The court can issue preliminary decree in any other matters as well. Court has that power. So let's move further. Here is a conflict of opinion as to whether there can be more than one preliminary decree in a same suit. Some high courts have taken the view that there can only be one preliminary decree in a suit, while other high courts have held that there can be more than one preliminary decree. As regards to partition suits, the debate is concluded by the pronouncement of the Supreme Court in Phulchand versus Gopal Lal, wherein it has been observed that there is nothing in the Code of Civil Procedure which prohibits passing more than one preliminary decree. Its circumstances justify the same, and it may be necessary to do so. But the above observations are restricted to partition suits. As court specifically observed, we should however like to point out what we are saying must be confined to partition suits. We are not concerned in the present appeal with other kinds of suits in which preliminary decree and final decree are also passed. So as regards to partition suits only, and only about partition suits, there is a judgment of the Supreme Court, that is Phulchand versus Gopal Lal AIR 1967 SC 1470, where it was stated that there can be more than one preliminary decree and then a final decree, but this judgment is restricted to partition suits only, as it was further observed by the court, and there the court specifically said that they are not concerned in that particular observation about any other cases, but only partition suits. In that case, there can be more than one preliminary decree. The question whether a decision amounts to a preliminary decree or not is one of the greatest significance in view of the provision of section 97 of the code, which provides that where any party aggrieved by a preliminary decree does not appeal from such decree, he shall be precluded from disputing its correctness and in any appeal which may be preferred from the final decree. Since the passing of a preliminary decree, it is only a stage prior to the passing of a final decree. If an appeal preferred against a preliminary decree succeeds, the final decree automatically falls to the ground, for there is no preliminary decree thereafter in support of it. It is not necessary in such a case for the defendant to go to the court passing the final decree and ask to set aside the preliminary decree. So what it says that if there is a preliminary decree where an appeal preferred was made, then the court passed a final decree, it is not necessary for the decree holder or any other person to go to the court and to ask the court to set aside the preliminary decree, because that decree will automatically be set aside by the court. So here we move on to the final decree. A decree may be said to be final in two ways. As we have just learned it before in the previous video, I'm repeating it again. When within the prescribed period no appeal is filed against the decree, or the matter has been decided by the decree of the highest court, and number two, when the decree, so far as regards the court passing it, completely disposes of the suit. So in the first point it says that if against that decree, that preliminary decree, no further appeal preferred was made, then that would be considered as a final decree, or the decree was decided by the highest court, that is Supreme Court. Or number two, it is not necessarily Supreme Courts, it can be High Court of competent jurisdiction. Number two, when the decree so far as regards the court passing it completely disposes of the suit, that the decree by which is in the controversy here, that completely disposes of the suit is completely concluded there by that decree, then that would be considered as a final decree. In this later sense, the words final decree are used here. The final decree is one which completely disposes of a suit and finally settles all questions in controversy between the parties, and nothing further remains to be decided thereafter. Thus, in a suit for recovery of money, if the amount found due to the decree holder is declared and the manner in which the amount is to be paid has also been laid down, the decree is final decree. Similarly, a decree passed from a sum representing past mentioned profit and future mentioned profit at a particular rate without directing any further inquiry, it is a final decree. Thus, where a decree passed by a special court did not contemplate any further proceedings, the decree, even though described as a preliminary decree, in substance was a final decree. So here it gives us three examples that if a decree is passed and that says that it is an amount to be paid by a person, and the amount in which procedure the amount is to be paid, and the particular amount is codified by the court that this much amount is to be paid, that is the final decree on that matter. Or in case of mentioned profits, if there is some representing past mentioned profit and future mentioned profit at a particular rate, court fixes that rate by which that mentioned profit would be counted, that is a particularly a final decree. Or without directing any further inquiry, if court does that, if court finalizes the particular rate, then that would be a final decree. Or another example that is given here is a decree passed by a special court did not contemplate any further proceedings, and the decree sounds like a preliminary decree, but that comes within the scope of the second point of the definition of final decree, that it completely disposes of the suit. So here in this context, that will also be considered as a final decree. Ordinarily, there will be one preliminary decree and one final decree in one suit. But in Gulshan PV versus Ahamdasha Rothar, the High Court of Madras, referring to rules 12 and 18 of Order 20 of the court, stated neither rule contemplates more than one preliminary decree and one final decree in one suit. In fact, the court nowhere contemplates more than one final decree in one suit. To have two final decree and call the first one final decree will be really misnomer, as it will not be the final. So here it says that the rule here contemplates which the decree that if there is two final decrees and you call the first one the final decree, then what about the second one? The second one is supposed to be the final, right? So there, in that context, you can't say that there can be two decrees. The final decree has to be one. So again, in Kashi versus Ramanathan Chettiar, the same court considered the question at considerable length. It was noted that there was divergence of opinion whether there could be more than one preliminary decree as also more than one final decree in a suit. Then, considering the question in detail and describing the observation in Gulshan Bibi versus Ovida Tikta, that is Ahamdasha Rothar, the court observed that there could be more than one preliminary decree and more than one final decree in a suit. Patanjali Shastri Justice, as he was then, rightly concluded the matter. Thus, the question is not whether the court allows more than one preliminary decree or one final decree to be made, but whether the code contains prohibition against a court in proper case passing out more than one in such decree. So, as he was said, Patanjali Shastri Justice, that the question here is not if the court permits more than one decree. The question here is, does the code prohibits more than one decree? And there is no provision in this code that prohibits more than one decree. So finally, this topic was concluded in the matter by Supreme Court in Shankar versus Chandrakant. And here it says that it is settled law and there can be more than one final decree be passed. So in this final case, the Supreme Court says that there can be more than one final decree. And if you go through this case, Shankar versus Chandrakant 1995 of SCC, Supreme Court cases 413, in this case it was held by the Supreme Court that there can be more than one matters in a particular case, more than one considerable facts, and giving one decree accompanying all the facts is not possible for the court. So the court has to give two final decrees. So again we move on to the last part of the decree, that is partly preliminary and partly final decree. A decree may be partly preliminary and partly final. For example, in a suit of possession of immovable property with mensne profit, where the court decrees the possession of the property A and number B directs inquiry into the mensne profit. So suppose in a case where there is a conflict between possession of an immovable property, the court has to conclude the matter who possesses the property. So there the court gives the decree in favor of a person saying that he can have the possession of that immovable property, but the matter of the mensne profit was not cleared till then. So the court again directs for an inquiry for that mensne profit. So here is one preliminary decree was passed which directs an inquiry into that mensne profit, upon which another final decree would be found, and court passes one final decree as well where it directs that one party particularly can have the possession of that immovable property. So here it is, the matter of decree is concluded, and on the next video we will do deemed decree along with other definitions. So if you have any question regarding this matter, please do comment on the comment box. I'll try to reach you as soon as possible, and also please do subscribe and share this video. Thank you very much.